Proceeds of Crime Act 2002. Introduction to the module. In this module, you will learn about the Proceeds of Crime Act 2002 and how it affects anti-money laundering measures. In this module, we will cover Introduction, the principal offences contained in Part 7 of the OCA 2002, the concealing offence, the arranging offence, the acquisition, use, and possession offence, the notion of criminal property, elements of criminal property, the concept of knowledge, the notion of suspicion. Introduction. POCA 2002 stands for the Proceeds of Crime Act 2002. This is an act of British law that entered into force in 2003. It governs the handling of money that originates from criminal activity. Section 7 of the Act covers money laundering. This module quotes from POCA 2002 and other sources. The parts in bold are our emphasis. You can see the entire Act online at. Please click the link. National laws are subject to change to reflect real-world changes. There may be updates to the Act in the future, or a new Act may replace it. The principal offences contained in Part 7 of POCA 2002. POCA 2002's definition of money laundering. POCA 2002, Part 7, Section 340, 11, sets out that 11. Money laundering is an act which constitutes an offence under Section 327, 328 or 329. Constitutes an attempt, conspiracy or incitement to commit an offence specified in paragraph A. Constitutes aiding, abetting, counselling or procuring the commission of an offence specified in paragraph A or would constitute an offence specified in paragraph A, B or C if done in the United Kingdom. The notion of criminal property. Sections 327, 328 and 329 of the OCA 2002, Part 7, address the concealing, arrangement, and acquisition, use and possession of criminal property respectively. POCA 2002, Part 7, Section 343, defines criminal property as follows. 3. Property is a criminal property if A. It constitutes a person's benefit from criminal conduct, or it represents such a benefit, in whole or part, and whether directly or indirectly, and B. The alleged offender knows, or suspects that it constitutes, or represents such a benefit. If someone knowingly helps to hide, or transfer the proceeds of crime, they are breaking the law. The concealing offence. POCA 2002, Part 7, Section 327, 1, states that 1. A person commits an offence if he conceals criminal property, disguises criminal property, converts criminal property, transfers criminal property, removes criminal property from England and Wales, or from Scotland, or from Northern Ireland. Concealing and disguising the money means keeping it hidden. Removing the money from the United Kingdom means taking it abroad. Converting the money could mean exchanging it for foreign currency or hiding it in another person's bank account. Transferring refers to transferring it to another account. In court, the prosecution would have to prove that the money came from criminal activity. The defendant knew about the origin of the money. The defendant deliberately tried to conceal or disguise the origin, nature, location or ownership of the money. The arranging offence. POCA 2002, Part 7, Section 328 defines arrangements as a person commits an offence if he enters into, or becomes concerned in an arrangement which he knows, or suspects facilitates, by whatever means, the acquisition, retention, use or control of criminal property by or on behalf of another person. As above, it is a criminal offence if the money is the proceeds of crime, and if the person arranging any transfers or use knows or suspects that If a bank begins to suspect that its client's money comes from criminal activity, this law puts pressure on the bank to report it. However, if a lawyer discovers that their client has criminal property, they are not guilty of arranging. The acquisition, use, and possession offense. Anyone who buys, accepts, or borrows the proceeds of crime is guilty of acquisition, use, or possession of the criminal property. Even for a bank, keeping the money in an account could be considered retention of criminal property. Converting it to another currency could be use, and transferring it to a trustee could be control. Authorized disclosures and adequate consideration. An authorized disclosure is a legal defense against arranging or using criminal property. In this case, the person receiving the money or arranging to transfer it suspects that the other party is laundering money. To use this defense in court, they must inform the authorities before receiving the money or as soon as they suspect that they are committing a crime. An adequate consideration is a possible defense against charges of acquisition, use, or possession of the criminal property. Usually, this applies in two situations. A legal advisor or accountant receives criminal property from a client. Someone receives criminal property as a repayment of an arm's-length loan, a loan in which the two parties do not know each other. Elements of criminal property. There is some subjectivity in the law concerning money laundering. Firstly, the accused party must know or suspect that the money that they handled was criminal property. Secondly, the money must be the proceeds of crime. If the court cannot prove this, they can demonstrate that the circumstances of the handling of the property bring one to the conclusion that it is criminal property. Partial and indirect criminal property. If the money is partially criminal property, or a possession was partially paid for with money earned through crime, then it is considered criminal property. Indirect criminal property refers to anything bought with the proceeds of crime. This is also considered criminal property. Furthermore, accepting a gift or payment in connection with criminal property is also a crime. For example, if someone bought a car from a known drug dealer and accepted a television with it, both items would be criminal property. The concept of knowledge. Though the law states that a person must know about criminal activity to be guilty, several criminal cases have set the precedent that constructive knowledge can apply. The College of Policing, in its page on money laundering offences, sets out that if the prosecution is unable to prove the original offence, then it is necessary to prove the irresistible inference that the property can only be derived from crime. This can be done by taking several factors into consideration, and these include previous convictions or bad character, association evidence, drug contamination on items such as cash and phones. The list goes on. Money laundering cases. You can access the page here. Please click the link. Not knowing that money is criminal property is not a defense if the court finds that a reasonable person would have realized constructive knowledge. Some cases that relate to money laundering include R versus Anwar and others. R versus Da Silva. You may want to read more about these. The notion of suspicion. To be guilty of a money laundering offence, the individual must know or suspect that the money or property concerned is criminal property. However, the suspicion is subjective. Several criminal cases have discussed how to define suspicion, notably R versus Da Silva. There is no clear consensus, but to be guilty, the defendant receiving money or goods must believe that there is a possibility that facts may exist that would indicate criminal activity to be guilty. The possibility must be more than fanciful. The suspicion does not have to relate to specific facts. Money Laundering Regulations 2007. MLR, Money Laundering Regulations 2007 were a further set of regulations. These imposed more commitments on financial bodies. Among these were to regularly provide anti-money laundering training for relevant employees. These should include how and when to submit a SAR, Suspicious Activity Report. MLR 2017 have since replaced MLR 2007. Summary. In this module, you have learned that in the UK, money laundering is governed by the Proceeds of Crime Act 2002. Money laundering comprehends a range of offences including concealing or transferring criminal property or helping or arranging for another to do so. Criminal property is defined as the benefit of criminal conduct. Knowing or suspecting that another person is laundering money is a crime. If a reasonable person could realize that money or possessions are the proceeds of crime, then that is considered knowing, constructive knowledge.